I'm sorry about that. The last three digits are 888.
Yes, ma'am. I have to check in. You can mute your microphone and wait for the judge to call upon you, okay?
Thank you. One thing I did notice on the ROA, it states that I am Tara Carson's attorney as well. I just wanted to make clear that I am only representing Oliver Management and Arnold and Evelyn Oliver.
Okay. Thank you.
Thank you.
Yes, ma'am.
All right, this is case number 1164193. This is Grossbeck RX LLC versus Indian Harbor. Matters before the court, settling for a pretrial conference. Your appearance for Grossbeck, please.
Good morning, Your Honor. Helen Cooley on behalf of plaintiff, P number 84581.
All right, good morning to you, Ms. Cooley. For the defendant, Indian Harbor, please, your appearance, please.
Good morning, Your Honor. James Lamb appearing on behalf of Indian Harbor, P number P84657.
Right, thank you, Counsel. Good morning to you as well. Somebody update me on where things are here. It looks like there's been some disclosures. I set the matter. I allowed some discovery that concludes today. Also allow for filing of motions by today's date. Update me as to how far along Ms. Coleman.
Your Honor, I had a chance to chat with defense counsel regarding this case. We did have some discovery exchanged, and recently they had the deposition of the underlying patient. They have not had an opportunity to evaluate the claim. It was taken this past Friday. So if the court is not opposed, we asked the court to give us 30 days in order to get the case going and hopefully resolve.
All right, Mr. Lamb, you think, sir?
That is correct. We did get the underlying claimant's deposition this past Friday. He's got a case currently pending in Wayne County. We just asked a 30-day adjournment to evaluate.
All right, well, it looks like the case is moving on with some degree of diligence. I would then find good cause for granting an adjournment of this matter for the next 30 days, and I'll take another look at it at the end of that period. I'm going to give you a specific date.
March 31st.
March 31st, 3/31, 22, and that's going to be at 9:30 a.m. 3/31/22. You'll get a notice in the mail with that date on it as well. It is an adjourned pretrial conference. Court will review the time.
Thank you, Your Honor.
Thank you very much, Your Honor.
Best. All right, court is calling case on 160-888. This is Carson versus Oliver Management LLC. Matter for after close of discovery. I did sign the previous order in this regard. I do see also that there is a motion, looks like a motion filed for summary disposition regarding this matter. Your appearance for Carson or Ms. Carson, anybody on that side is here now. Say something at this time, Peter.
I'm here. I'm Carla Carson.
All right, thank you, Ms. Carson, and good morning to you, ma'am.
Good morning.
All right, for Management LLC and Evelyn Oliver and Arnold Oliver, your appearance at this time for the record, counsel.
Yes, good morning, Your Honor. Attorney Jessica Warfield, P85391, on behalf of the defendants in this matter.
All right, thank you, Ms. Warfield, and good morning to you, ma'am.
Good morning.
So
And for the record, Your Honor, I do want you to know that Ms. Evelyn Oliver is present via Zoom.
All right, thank you, counsel. All right. It looks like I granted an order for a more definite statement. And then subsequent to that time, I see that there is this motion for summary disposition regarding this matter. Ms. Carson, did you get a copy of the motion for summary disposition in this case?
No, I didn't.
Okay. All right,
Your Honor.
I see that at least my timestamp has that filed on the 22nd of February. Is that about right?
You said, who, you talking to me, Your Honor?
I'll tell you, Ms. Warfield. Ms. Warfield, were you able to hear me?
Yes, Your Honor. We did send that out. Now, Your Honor, there was not an address for Ms. Carson. We tried calling the court several times to obtain that. We did run our own search and found that Ms. Carson was using a PO box, and that is what we sent the motion to.
All right. And I'm seeing in the file an address on Coram Street. Did you send anything to that address?
No, Your Honor, because that is actually the address in which my client previously has evicted Ms. Carson from. So she's no longer there. She hasn't been there.
All right, thank you. All right, Ms. Carson, there is a motion that has been filed with this court, and the plaintiff, that defendant in this matter, tried to get that to you, and they sent it to a post office location.
Yeah.
PO Box 2410. Is that a correct post office box for you?
That's a correct post office box, but at this time, my mother, she have cancer, so I have been taking her back and forth to the doctor and all like that. I haven't checked the mailbox. I was checking it tomorrow. Last time I checked, I did not have it.
All right, very well. Okay, so yeah, in counsel, it looks like the filing with the court, or at least the timestamp, is February 22nd on this. That about the time that this was submitted to the court? Yeah, you're on mute, but it looks like you're speaking.
I'm sorry. Yes, Your Honor, that is correct. The 21st was a holiday, so it did go out on the 22nd. Yes.
All right, gotcha. All right, so what I'm going to do, given that time frame, I am going to go ahead and adjourn the hearing on the motion to give Ms. Carson the opportunity, number one, to receive the same, and number two, to respond to the document that she wishes to do so, and then I'll make a decision on the motion at the next hearing. So, Ms. Carson, I'm going to set this motion over for a subsequent date, and I'm going to direct that Ms. Warfield would send it once again to the PO box address, unless, ma'am, you are willing to provide some other location that it can be sent to.
That's the only location I have, and they know that.
I'm still talking. I don't listen to other people when I'm talking. Okay, so you gotta wait. You gotta wait till I finish talking. You can also choose to provide an email address that could be emailed to you, ma'am. So, what do you wish to do at this time, Ms. Carson? I want to make sure this gets to you.
They have both at the end of the day, because if they was working with the other Gary Seghetti, he had my PO, my phone number, and my email address.
Your Honor, the number that we were provided from previous counsel was not working, and we do not have an email address for Ms. Carson. That is the reason why we only sent it to the PO box.
So, Ms. what I'm going to do is I'm going to put you in a breakout room with counsel for a moment so that you can provide her with an email address. They'll send it to the PO box, but if you want to get certainty, having more than one location to do that is obviously a great way to do it. That way there is privacy in doing that. So I'm going to give you notification to breakout room number 1, ma'am. And the attorney is going to be sent there as well. In the interim, so that you won't have to come back here, I'm going to go ahead and give you the new date. Let's go ahead and put it on the 31st. The 31st at 9:45. That's going to be March 31st, 9:45. The next hearing date regarding this matter. You will get a notice in the mail to the extent that we're able to send out a notice to a correct address. But that is March 31st, 2022 at 9:45 a.m. So now I'm sending you, Ms. Carson, to a breakout room, and Ms. Warfield is going to meet you there. So you have a private moment regarding information. There you are.
Thank you, Your Honor.
Thank you, Madam Counsel. Good day to you, ma'am.
Same to you.
All right, this is case number 21-167-567. This is Beaumont Health versus Sharon Pennington. The matter is before the court. Looks like it's set on for a hearing. Sounds like this is the first time that this matter is up before the court. Your appearance for Beaumont Health, please.
Thank you, Your Honor. This is Hal Burke, attorney P69068, and I apologize to the court. The notice and Miss Pennington's was the same. She mentioned had the wrong Zoom code. So please accept my apology for tardiness, and I do want to try to resolve it with you, Your Honor.
Gotcha, sir. And good morning to you. Let's see if I have Miss Pennington here. If you're here, ma'am, say something at this time.
Yes, my name is Sharon Pennington.
All right, thank you, Miss Pennington, and good morning to you, ma'am.
Good morning to you.
So it looks like there's a claim that has been filed in regard to this matter that alleges that there's about $1,800 that's owed in this matter. And it also looks like there is a willingness to try to talk about this to see if there's a way to reach a resolution in this matter. So I'm going to take a moment to place you in a breakout room to talk with the attorney on the other side to see if you can reach some common ground as to how this case might be resolved. That makes sense to you, Ms. Pennington?
Yes, I understand.
All right.
Your Honor, can a breakout session be had when she's on the phone? I'm not positive.
I think that she zoomed in. You'll get
Oh,
a
she did.
notification. Yeah, yes, you'll get a notification on your device, ma'am. It will place you in a breakout room number 2, and then the attorney is going to be there as well. And you have a chance to speak mutually. Just one moment, Ms. Warfield.
I really don't understand, but I guess.
So let me know when you see a notification to go to a breakout room. That gives you opportunity to talk with the attorney that represents the other side and to talk about whether or not you can find a way to get it resolved. So I'm sending you the notification now. I want you to look at your phone and tell me if you got it. Did you receive it? Well, she's already there, so she's got it. So Mr. Burks, I'm going to send you there.
I did not get it. I got it now. Thank you, Judge.
Thank you.
Thank you.
All right, this is case number 21-161-349. This is Michigan First Rehab versus Nationwide Mutual Fire Insurance. The matter is before the court on the adjourned date of hearing. And on the previous date, there was a pending deposition. The court set it over for today's date, which should be after the deposition was completed in this matter. Your appearance for the plaintiff at this time, please.
Good morning, Your Honor. Connor Clorty, P84485, appearing on behalf of Michigan First Rehab.
Thank you, Ms. Corrigan. Good morning to you, sir.
Good morning, Your Honor.
For the defendant in this matter nationwide, your appearance at this time, please.
Good morning, Your Honor. Dan Gumto appearing on behalf of defendant Nationwide, P82748.
All right, thank you, sir, and good morning to you as well. Somebody go ahead and update me on the status of things. I know it was talking about awaiting the death of the plaintiff. So where are we, if you will?
Your Honor, right now, we have not really had a discussion yet about settling this case. It would be beneficial, I think, for the parties to go into a breakout room to do that before we proceed, if the court is willing to do that, and if defense counsel is also willing.
Your Honor, we were able to secure the deposition of Ms. Wilson last Thursday in her own suit. So, there's some additional discovery we need to conduct based upon her testimony. If the court would be willing to grant a brief adjournment, I think that would be helpful in this matter. I don't know if there's really a point for a breakout room and settlement negotiations, as we just had her deposition last week.
Well, Your Honor,
The stage, given that you need some more information. Is that what you're saying? Mr. Gunton?
That's correct, Your Honor. We've received plaintiff's initial disclosures, but we don't have any of the records from plaintiff's facility, and those have been ordered. We're awaiting those.
Ms. Fleury.
yeah, Your Honor, this is the first time hearing about this. I did just substitute it on this case for Ms. Toma. I'm not sure why defense counsel is saying he's not willing to speak, but that's fine. If he wants the adjournment, we'll be more than willing to provide it.
Well, I don't think that he was saying that he was not willing to speak. I think he was, at least what I heard is that at this point, he believes that there's more information that would be helpful. That would be helpful to having any fruitful discussion. That seems to be the tenor of things. Is that about the size of Mr. Gunton?
That's correct, Your Honor. That was it. It's not that I wasn't willing to. It's just that we, for a fruitful conversation, we're going to need a little more information.
All right, that makes sense. So I'll go ahead and find good. Looks like progress is being made. Plaintiff has provided initial disclosure information there. The deposition is now been taken, and more time to position this case where the parties can talk more fruitfully about resolving the case. Go ahead and set it over the 31st of March. I'll bring it back and it's set for 9:30 on that date. That's 3:31, 9:30 a.m. The court finds good cause for the adjournment in this manner.
Thank you very much, Your Honor.
Thank you, Your Honor. Thank you.
This is case number 21-164457. This is Credit Acceptance Corporation versus Denitra E. Burns. The matter is before the court, set up for a pretrial conference and motion and hearing on a motion for summary disposition. Your appearance for the plaintiff regarding this matter, counsel.
Judge, may it please the court, Attorney Richard Rusin, my bar number is 35222. I'm the attorney of record for the plaintiff. I'm also the petitioner in plaintiff's motion for summary judgment.
All right, thank you, counsel. Good morning to you. I am looking now for Miss Denitra Burns or someone representing Ms. Burns. Say something if you're on this Zoom at this time, please. Miss Denitra Burns, if you're on this Zoom, Ms. Burns, please say something at this time, ma'am. All right, this matter was set on for the motion for summary disposition at 9:45 a.m. Also for the pretrial conference. Once again, I am looking for Denitra Burns, living on 12th Street in Ecorse, Michigan. If you're anywhere on this Zoom, please say something at this time. Counsel, when, if any, was the last time you had any contact with the defendant in this matter, sir?
Well, Judge, I can tell you as an officer of the court, the defendant is improper, and really the only time I've had personal contact with defendant is on the record. So she has not, he called our office way back in October when she was served. And then the court went into pretrials and status conferences. So except for the one time that she actually telephoned my office on or about October 12th, 2021, and the court record, I've had no further contact with her.
And it looks like we sent the notice to an address in Ecorse. Throughout the file, it looked like she had an address on Riverfront in Detroit.
Yes, yes.
I see that she provided that alternative address to the court the last time that I was here. All right. Yeah, anything further at this time, Counsel?
Judge, I rest on my pleadings, which you have before you, and I ask that you, in your discretion, your judicial discretion, that you either grant a failure to appear default at this time, or you grant the plaintiff's motion for summary disposition, and on that I rest.
Thank you, Counsel. Just one moment. All right, inasmuch as the defendant has not appeared, the court has provided notice regarding this case. I looked at the notice again to make sure that the correct Zoom address and all of the information is correct in that regard. The court would then find that where the defendant has failed to appear, the defendant is now in default in this matter. The court will enter the default of the defendant and will enter judgment on that default upon judgment to the court. So,
Thank you, Judge. I will set a default judgment by 7-day rule after the 21-day period expires for the default entry today.
all right, so thank you. The court waits.
All right. Thank you, Judge.
Case number 21-168794. This is Velocity Investments Incorporated versus Geraldine Stevenson. The matter is before the court on an application for entry of judgment by default. The default has been previously entered. The plaintiff is requesting entry at this time. Your appearance for Velocity, please.
Good morning, Your Honor. Brad Johnson, P75416, on behalf of the plaintiff.
Thank you, Mr. Johnson, and good morning to you, sir. I'm looking now for Geraldine Stevenson. If you're on the Zoom, please say something at this time.
This is Geraldine Stevenson.
All right, thank you, Ms. Stevenson, and good morning to you, ma'am.
Good morning.
Right, this is before the court on the plaintiff's request that the court enter the judgment. Default was entered regarding this matter in November. And that default was entered because you did not respond to the underlying complaint in this matter. And after a certain number of days, the default will enter automatically. So today is the date set for entry of the judgment itself. Why do you believe that the judgment should not enter it, or do you believe that?
I was in a car accident and I've been sick ever since. I haven't worked. I don't know. I didn't get any information from anybody. And if I did, I don't remember it because my my memory has been bad since the accident. And I really don't even know what this is about. I just got this, my grandson gave me this paper. Somebody gave him in the mail. I mean, at the door.
All right, ma'am. So it looks like this case looks like it arises out of a out of the use of a credit card or line of credit with Mercury Credit Services. And that the allegation is that some indebtedness was not paid on that card, and that's why the lawsuit was brought.
I paid all my, I don't remember the exact, but I paid after the accident. When I got some money, I paid all of the cards under the amount so it wouldn't be over. And then I shut down all the cards. And I haven't worked or been able to, and I was going to send them some money when I got my income tax. I wasn't able to file my income tax last year. And but I pay all my bills on time. And I made sure that I called each company that I couldn't pay, paid the amount so it would be, I wouldn't be over, and shut down all the accounts. So I couldn't accrue any more, any more charges.
All right. All right, counsel, you may at this time, sir.
Yes, Your Honor, this is relating to a credit card that was opened in November 2007, and the last payment was in January of 2020. So I don't know when Miss Stevenson's accident
January 1st, 2020. Well, there was the New Year's Eve that night.
Okay, well, I guess that tracks, Your Honor, but I mean, this card was in had charges and didn't have a zero balance, all the way up.
I didn't pay a zero. I paid the amount under. When I got some money, I paid under, so I wouldn't be over.
The other side is talking now, so you gotta wait till they get finished.
I'm sorry.
Thank you, Mr. Johnson, you can continue. I mean, the problem here, of course, is that Ms. Stevenson is in default. She's likely got to file something to try to get that set aside. And I don't see, I'm not seeing a good cause or a meritorious defense, at least at this hearing. But she would certainly have the right to file something to try and get this set aside if she believes that a judgment should not be entered. But go ahead, you wanted to give me some formulation of facts in this matter, Mr. Johnson. Well.
Oh, sure, Your Honor. It's a credit card that was opened in November 2007. Like I said, the last payment was in January 3rd of 2020. So that all tracks. We received a letter from allegedly Miss Stevenson on November 13th, 2021. I don't know if the court received that.
I don't believe that I did. What was that letter about?
It's a standard kind. It's like a dispute letter. It's not really responding to the complaint itself. It's more just kind of a boilerplate FDCPA validation request. It says it's CC the 36.
I'm sorry, I did receive that letter dated November 13, 2021 from Ms. Stevenson, raising a dispute. Looks like primarily directed at the credit reporting agencies and alleging violation of the Fair Credit Reporting Act, violation of Fair Debt Collection Practices Act. Go ahead, counsel.
I mean, it does look like she's made some effort to respond to the complaint, although it's not really responsive under the court rules. And that was, I guess, sent before the default was entered. I mean, I'm willing to give her time to, if she wants to do an amended answer that complies with the court rules and get this case on track. I mean, I'm willing to do that. I'd rather do that than go ahead with this judgment and move to set it aside. And I want to give, she at least made some effort prior to today's hearing to address the complaint in a legal setting.
Got it. All right. So yeah, ma'am. And I'm just noticing that, Ms. Stevenson, that you did send something in on this case in November, but it was not in the form that it would normally be sent. That is an answer to the complaint. So the case has you in default. It looks like statements that counsel made I would likely set the default aside at this point and give you a chance to go forward to try to defend against this case. It sounds to me like a situation where you kind of need to see if you can talk about resolving it and come up with some dollar amount that might resolve the case, because it seems that you paid some and then you stopped making any charges, but there was some amount that was left over. And that's what they're suing you for, is the amount that was left over that hasn't been paid. So it might be worthwhile. It might be worthwhile to go into a breakout room and talk about whether or not you can come to agreement with what the amount should be and a way to pay it back, because that's what this case is about. You understand what I'm saying, Ms. Stevenson?
Yes. I understand.
All right. So I'll go ahead and set the default aside at this time. And Mr. Johnson, if you have a moment, I'm going to send you and Ms. Stevenson into a breakout room to talk about what the issue is, whether you can get this resolved with some dollar amount and perhaps a repayment.
Okay.
So, Ms. Stevenson, you're going to get a notification for me to go to breakout room number 1. And so it's going to come up on your phone. There it is.
Mm-hmm.
And Mr. Stevenson, so just click in, ma'am. And Mr. Stevenson, straight there, Mr. Johnson is going to receive the same notification to go there as well. There you go.
Do we have to come back, Your Honor, after this meeting?
Yeah, just to get, come back in to get a date for the next hearing. If you get it resolved, come back in and let me know that, but if not, come back in so we can get a date. Maybe I can give you a date now. Hold on 1 second. 1 second, then you can let her know about this date as well. To come back on this week. So March 31st, Council, March 31st, 9:45 a.m. March 31st, 9:45 a.m. So if you get it resolved, come back in and let me know and figure out what to do from there. If not, you know that that's the next date in this matter. And I'll treat the defendant's submission as her answer in this matter, and then we'll go forward.
Okay, very good. Thank you, Your Honor.
Thank you, Counsel. And regarding Beaumont versus Pennington, the suffix is 567. And Mr. Burke, I see that you're there. Do I have Miss Pennington back in this segment?
Yes. Yes, Sharon Penn.
Thank you, Ms. Pennington. Mr. Burke, if you'll update me, sir.
Yes, Your Honor, we thank you for allowing us to go into the breakout session. I believe that Ms. Pennington thinks this is an insurance issue. Again, without giving her legal advice, with your permission, I recommended maybe we would ask for one more pretrial date in the next month, and she could have some time to find out why her insurance did not get paid or did not pay it. And she mentioned that would be the source of anything to try to resolve the case. I defer to you.
Sounds reasonable. So, Ms. Pennington, you're gonna by granting adjournment, you're gonna spend that time trying to see if and why your insurance company would not take care of this matter. If they will, that would somehow resolve the case. That what you want to try and do, ma'am?
Yes.
All right. So I'm gonna go ahead and set it up for a next action date. 4/6 is going to be that next date, 4/6/22 at 9:30 a.m.
Thank you, Your Honor.
All right.
All right. Thank you.
All right. You'll get the notice in the mail as well.
Okay.
Thank
All
you.
right. Thank you. Uh-huh.
This is case number 2016 CR336-2399. This is Laboratory Specialists of Michigan versus City of Detroit. The matter is before the court, set on for a motion of hearing, a motion for summary disposition here. Your appearance for Laboratory Specialist, please.
Good morning, Your Honor. I'm Muzim on behalf of plaintiff P84247.
All right, thank you, counsel. Good morning to you. For defendant City of Detroit, you may counsel.
Yes, good morning, Your Honor. Philip Hiltner, P77913 for defendant.
Thank you, Mr. Hilton, and good morning to you as well, sir. All right, I think that the last time we were here, I adjourned the hearing on the motion because the motion had not been received or something along those lines. About the size of it.
I think so. So last time we had filed a motion for summary disposition, which was granted, and then plaintiff filed a motion to set aside that judgment so we could have rehearing on that motion. So my understanding was today we were going to have rehearing on the motion for summary disposition.
So, yeah, I knew it was something kind of quirky here. So I granted the motion, and Madam Counsel, you're asking for a rehearing on that motion?
Yes, Your Honor. The first time we never received the motion, so we didn't know what the motion was about. But we did get the motion, and we had a chance to actually look at it this time and see what it was about.
All right, so this is your motion then to set aside my previous ruling or something along those lines?
We had already ruled on that motion. So now this is the motion, original motion that defendant had filed. So we already set aside this in our last hearing. And so now we came back so we can actually go through the motion.
Thank you. Thank you.
Thank you.
Thank you for clearing that up. That puts it all together. Got it. All right, Mr. Hiltner, you may at this time, sir.
Thank you, Your Honor. I think our motion is fairly straightforward. This is a PIP provider case. So plaintiff is claiming benefits on behalf of Charmaine Stampley under the no fault statute. Under that statute, MCL 500.3107 sub 1 says, allowable expenses, so benefits that can be claimed, are reasonable charges incurred for reasonably necessary products, services, and accommodations for an injured person's care, recovery, or rehabilitation. Our argument is that they haven't satisfied that portion of the statute, or they don't have evidence in support of that portion of the statute. Plaintiff allegedly provided drug screening services for Ms. Stampley, but we have never received, and we requested, some sort of prescription for the underlying medications or something prescribing these drug screening services. So the drug screening is usually done right when someone's prescribed, pain medication. They have to do a screening just to make sure they're not already using, a similar substance, or there aren't substance abuse issues. But we just don't even have evidence of the underlying medications that would necessitate these drug screening services. So without that, we can't consider these benefits reasonable or reasonably necessary. And so we're entitled to summary disposition for that reason, pursuant to Michigan Court Rule 2.116C10.
All right, so Counselor, I'm sure you got it, Madam Counselor. Essentially, Counselor is saying that under 31071, the services by virtue of the statute would have to be reasonably necessary, and that is a predicate to showing that in this case, in particular, that there would have to be some showing that the services were necessitated either by the issuance of a prescription or some other medical workup that would justify such services. You may respond this time.
Yes, Your Honor. The only thing that we were able to get from the provider was the requisition form that Nicole Wick had sent over when they ordered the test. We weren't able to get our hands on any records for any prescriptions. All we had was a requisition form that was sent to the lab.
So on your best argument on reasonably necessary medical services, your best argument in that regard.
Yes, Your Honor.
I'm sorry.
I said yes, Your Honor. That's all. I mean, that's all my client had forwarded to us. We couldn't obtain any more records. All we had were the lab results and the requisition form from the underlying provider.
Gotcha. Well, I thought you were going to formulate some extraordinary argument to show the reasonable necessity of the services here, and based upon that requisition form. Let me go back to Mr. Hiltner. Sorry, anything?
Right. Yeah. Yes. I would just simply say the requisition form alone is not enough to create a question of fact on the reasonableness or necessity of these services.
All right. Anything else on the motion at this time? Response or otherwise?
No, Your Honor.
No, Your Honor.
All right. Thank you. The court has listened to the argument on the motion for summary disposition. It appears to me that the best information that could be provided is that a requisition form was sent over regarding the services that were ultimately rendered herein, but that such a requisition form does not provide the predicate that will satisfy the requirements of the statute for a showing of reasonable necessary services herein. For that reason, defendant's motion for summary disposition is granted at this time, as the court could not find, even when viewing the evidence, arguments, pleadings, and the like most favorable to the plaintiff, the court could not find a basis to conclude that the services were reasonably necessary. If the services that were provided were reasonably necessary. Accordingly, again, the motion for summary disposition was granted.
Thank you, Your Honor.
Thank you, Your Honor. Would you like me to submit an order?
I'll issue an order, and
Okay.
you'll get it in a day or two. All right. Thank you.
Okay.
Thank you, Your Honor. Have a great
Thank
day.
you, Your Honor. Take care, everyone.
This is case number 21-152-874. This is Biomolecular Integration Incorporated versus Allstate Insurance Company. The matter is before the court. Looks like set it over for pre-trial. All right, so do I have the plaintiff in this matter, Biomolecular Integrations? Do I have someone from Allstate at this time? Let me call that after my last case. And then is represented by Ms. Coley. It looks like she was here earlier on another case. All right, the court then will revisit that momentarily. This is case number 21-162-798. This is Metro Med Pain Management versus City of Detroit. The matter is before the court settled for a hearing on today's date. The court did allow for discovery through the 14th of February. Looks like there was an adjourned dated hearing. Previous date in this matter was the 14th of February. And it looks like the parties may have resolved the case, is what is a note that I'm looking at. All right, for the first of all, for the plaintiff, do I have someone from Metro Med or defendant in this matter, City of Detroit, Madam Counsel?
Yes. Good morning, Your Honor. Gina Smith Gallant on behalf of the City of Detroit, P number 41387. Your Honor, I appeared today because I did see a notice, but our offices were talking settlement. We were very close. So I am, I can't say that we resolved it, but we were very close. I think it will be resolved. I should say that. So if you would just give us a few more days. We can come back and confirm with the note, release and dismissal.
All right, sounds reasonable. Sounds reasonable, Madam Council. I'll go ahead and set it out just a couple of weeks, maybe 2 weeks to review it.
Okay. So we'll receive a notice.
Yeah, 3/14/2022 at 9:30 a.m.
Thank you, Your Honor.
Thank
Have a
you.
good day.
Okay, as well. Again, the court is on the record regarding the suffix H74. That is biomolecular integration versus Allstate Insurance Company.
They didn't come because they submitted a dismissal, but we don't have it. It's not in there.
Is that what it is?
Yeah, they submitted a dismissal. I don't think it came up yet.
All right. It appears that the parties in this matter have submitted a proposed order of dismissal to this court, indicating that they've resolved this matter in some fashion. The court has not formally received the order, but will respond to this matter. Accordingly, I will await the dismissal. I'm seeing a Sabrina Brown on the Zoom, ma'am. Why are you here, ma'am?
I think I am in the wrong courtroom Zoom. Your name is Donna Wood.
I'm sorry, say that again. I heard you say you get a wrong
What is your Donna? What is your name? Donna Wood.
I'm Judge Cook, Donald Coleman.
Oh, I'm supposed to be in Judge Greaves with Donald Greaves. Is that his name? 532. My Zoom had went out and came back in, and I got you.
Okay, well, let's find out where you're supposed to be. What Zoom number did you have where you're supposed to be?
537.
Yeah, this is 336. So you gotta go back out and dial, 360-537 and then 000.
Okay. Thank you.
All right,
I'm sorry about that.
have a good day.
You too, huh?